actually a possibility. The motion had been filed in October of 2024, but in January of 2025, he brought an illegal cell phone into the prison setting, enlisting another prisoner and someone outside to do that for him. He was caught violating the rules. And the psychologists looked at that and they said, if someone is willing to risk engaging in a rule violation while they're actually involved in a resentencing, what does that say about their risk of conforming to the standards of the law if they were released outside of this structured environment? And they determined that they posed a moderate risk of violence as opposed to the low risk which had been assessed before. With Lyle Menendez, they also looked at a variety of rule violations in which he had engaged in, reaching the same conclusion, that he no longer posed a low risk of violence in the future, but posed a moderate risk. So we used this new information to renew our motion. And we said to the judge that this new information effectively meets the legal standard to allow a district attorney to withdraw a motion that had previously been filed, because it shows that a change of circumstances where the prisoner is less deserving of resentencing. That is the standard. A change of circumstances where a prisoner is less deserving of resentencing. And we made that argument to the judge, and ultimately we said that the issue with the Menendez brothers is not never, that they should never qualify for resentencing. We said it was not yet. That in light of the findings of senior psychologists from the Board of Parole, in light of the prior arguments that we had made, that the Menendez brothers had never come clean for over 30 years, with the fact that their self-defense defense, where they said that their parents were going to shoot them each, the mother and the father, the night of August 20th, 1989, so they had to shoot them first. The lies where they tried to enlist one of Lyle Menendez's girlfriends to say that Jose Menendez was a violent rapist, a complete lie she would not say. The fact that they enlisted another girlfriend to go ahead and lie and say that the mother was going to and tried to poison the entire family. These are the significant lies that the Menendez brothers have never come clean with over the last 30 years. You add in the findings now by these board-certified psychologists that also talk about deceit. Deceit meaning that they are no longer constitute the low level of risk, but have risen to a moderate level of risk. And that's why we asked the court to allow us to withdraw that motion at this time. It doesn't mean that we wouldn't refile the motion in the future if circumstances change to show that the Menendez brothers have truly gained full insight into their actions and accepted responsibility, but that time was not now. The court heard all our arguments and denied our motion. So the court then set the resentencing hearings for for Tuesday and Wednesday of next week, at which point witnesses will be presented, and the court will either rule at that time or take it under consideration. I'm now open for questions. We anticipate that parts of that report will actually come into evidence and be considered by the court. The court will view the comprehensive risk assessment in the total context of how that plays out, even for the parole board. So, for instance, that comprehensive risk assessment, though very detailed, is something that at the parole hearing would have additional information that would be brought to the parole board's light that would potentially either corroborate what's being said in that risk assessment or it could actually contradict it. The parole board will make the final call on the weight to be given to the comprehensive risk assessment, and the court will do the same as to the weight he gives to this comprehensive risk assessment.
The allegation that by Garibald's that you're using your firm, LAG, used it in the campaign to, as he says, campaign against the Menendez family. Yeah, that's a violation of what you have to say.
So again, this shows you what happens when people want to pretend that there are facts in the record to just, to really go after someone's reputation, when they absolutely are not only wrong, but they've done no due diligence to ascertain the true facts. One of the allegations that was made by Mr. Garagos and Mr. Freeman in open court, and by the way, they made these allegations about the recusal motion as they were withdrawing the recusal motion at the same motion. So it gives you an idea of the quality of the evidence they were relying on, they said that I had hired a firm for hundreds of thousands of dollars. They identified that firm as Lag Strategy in order to put anti-Menendez messaging out there in the community. What they would have found out is that firm was hired during my campaign. It had nothing to do with the Menendezes. That firm hasn't worked for me since the campaign. The campaign was over November 5th. That firm has not put out anti-Menendez messaging. So it gives you an idea of the quality or lack thereof of the information that the Menendez brothers' attorneys and Mr. Friedman, on behalf of the victims, wants to put out, hoping that that somehow will sell in the media of public opinion. Shame on them. Shame on them to try and actually go ahead and do that. They want to go toe-to-toe with the facts and the law. Bring it on. We are happy to have a factual disagreement based on real facts, but we're happy to have legal disagreements. And that's what you've seen in sort of the interplay between ourselves and the court. But when Mr. Geragos and Mr. Friedman want to go ahead and make these spurious and salacious accusations in order to, I don't know, gain media attention, shame on them.
District Attorney, when it comes to laying out the case next week, who do you plan on hearing from, and would you like to be able to cross-examine Lyle and Menendez?
You know, the determination of who exactly will be called as a witness in the case and what, if any, witnesses or documents will be using to respond, that will be determined next week when we get closer to that hearing.
Would you like to hear from Lyle and Menendez?
Again, whether or not we hear from Lyle and Eric Menendez will most likely be a determination made by their lawyers in connection with consultation with any expert that the defense has. Again, I don't know the answer to that. They might still be on Zoom or they might appear for the hearings.
To clarify, the CRA report will not be allowed in the resentencing hearing?
So the judge has preliminarily said that he will consider the CRA, the Comprehensive Risk Assessment Report. He will also consider any arguments dealing with the weight of the report and effectively how much importance he should give to the conclusions of this Comprehensive Risk Assessment Report. Those arguments will be made by the defense in connection with its admissibility. But we ultimately believe the judge will consider the report at whatever level he deems it important.
In light of the CRA report, if Lyle and Eric Menendez are given their freedom, do the people of Los Angeles have something to fear?
Again, the analysis is risk of danger to society. Part of the reason that we have asked not to have the resentencing go forward at this time on the people's own motion was precisely because we have this additional new information coming in from the Board of Parole senior psychologists that have assessed that risk as a moderate risk. Not a high risk, not a low risk, but a moderate risk. So again, it is a risk analysis, and that risk right now is at a moderate level.
Mr. Harper, how do you personally feel about today's ruling?
I'm sorry?
How do you personally feel about today's ruling?
Again, my personal feelings are completely irrelevant. My job, as I explained to the court, is to bring the facts, all the facts, and the relevant law to the court's attention so that the court makes the best decision possible. We did that today. So to the extent that we have accomplished our purpose, as we will today, and every day we are in court in the Menendez hearing, that is the goal.
District Attorney, your thoughts on the judge saying that the cell phone charges and prior tax fraud, just wasn't serious enough to consider, wasn't different enough?
You know, again, the judge is making that determination. The determination we argue to the court is whether or not the prosecutor had a legitimate reason to take that information, couple it now with this new finding by board-certified psychologists who've conducted comprehensive risk assessments and now found a moderate risk, couple that with our other arguments of deceit that we've explained before, and then make the request to withdraw that motion at this time because we don't think resentencing is appropriate at this time. So we have made that request, the court denied it, and we respect the court's ruling.
Just to be absolutely clear, so he's going to decide during next week's hearing whether or not the CRA report is admissible?
Yes, so he will decide the final conclusion of whether or not he will accept the report and it's admissible, for what purposes, what part of the report, and what weight he will give it.
So you guys cannot use it as of now.
So again, it will be introduced in the hearing, and then we'll find out what the court's going to do with it. All right, thank you all very much. Appreciate it.
Down. Sit down, please.
Look, we're very grateful to Judge Justice.